Hello everyone, welcome to Angela Nickel Music, and I have a question for you. You've worked hard to make your music. You deserve to protect it, and you deserve to get paid for it. The question is, do you know how? In this video, I'm going to share 6 things I wish I knew as an indie artist so you can avoid making the same mistakes that I did. When I started in the music industry, it was around 20 years ago. I knew nothing about copyright, protecting my music, or how to get paid. All I cared about was getting my music heard and hopefully finding a label. This lack of knowledge cost me time, it caused me to lose money, and it's left me vulnerable for others to use my work without permission. So I want you to learn from my mistakes. I don't want this to happen to you. In this video, I'm going to share 6 important topics, which include composition copyright, sound recording copyright, registering with a pro, licensing, collecting royalties, splits, and work for hire agreements. Now, before we get started, please take a moment to like, subscribe, drop a comment, and share this video with other artists so they can learn these important concepts as well. Copyright 101. Own your work before someone else does. I'm not a lawyer, I'm just sharing what I'm learning myself, so please contact an entertainment attorney if you have any legal questions or concerns. So you've come up with a great idea for a song, you've written the lyrics down, come up with a melody. According to US copyright law, you own this copyright to the song, specifically the composition. Once you get it produced and recorded, you now own the sound recording. So the composition is the lyrics, the melody, harmonies, and this is owned by the songwriter. The sound recording is the actual recorded performance, your vocals, instruments, production, and this is owned by whoever records, performs, and produces it. I plan to elaborate on the differences between composition copyright and sound recording copyright in a bit, but for now, I want you to know why it is so important to formally register your work with the Copyright Office. Registering with the Copyright Office offers stronger proof that you're the official owner. If you write a song and someone tries to use it without your permission, you can prove much more easily that you own it. It's easier to secure contracts with publishers, distribution deals, or sponsorships with publishers and record labels, as well as obtain sync licensing. You can collect international royalties much more easily, enforce your rights globally, and collect royalties from international markets. Tracking and claiming unauthorized uses across different countries becomes much easier. Statutory damages. You can ask for statutory damages without proving how much you lost. Please note that this applies per infringement and only if the work was registered before the infringement occurred or within 3 months of publication. And finally, you can file a DMCA or a cease and desist. The bottom line, registering your song first gives you stronger protection and more money if someone tries to use it without your permission. In a future video, I'll cover more detail of composition and sound recording copyright filings, but for this video, I'm going to share the high-level overview just so you understand the basic differences. So that brings us to composition copyright. To illustrate composition copyright, I'll use my own song, No Power Over Me. In 2007, I came up with a poem. You can't tell me what to say, what to do, or who I should be to you. No, you can't say what to think, what to feel. You have no power over me. Then I wrote additional lines around that. I had my lyrics, and that was the beginning of my composition. A few weeks later, I came up with a melody. Now I had a complete song concept, lyrics, the melody, and from that melody, an implied chord structure. At that moment, I had a completed composition. Even though it wasn't produced or recorded yet, at this stage, I could go to the Copyright Office and file a Form PA, which is a Performing Arts Copyright Form. Since I had not shared it online yet or made it available to the public in any way, when I registered it, it wasn't considered published. A song is not published until it is made available to the public. So the moment you put it on YouTube or share it on your social media, that's when it's considered published. Now, if I shared what I wrote with someone and they tried to claim ownership, I could now prove that I had created it first. Also, if someone wanted to use my composition to record their own version of a cover song or a new song based on my work, I could get paid for it. And don't worry if you publish the composition later, after you've registered the copyright, it's still valid. That brings us to the sound recording copyright. The process of registering the sound recording copyright is very similar to registering the composition. You've got your composition, you take it to a producer, or you sit down in your own studio. You arrange the music, add the details, and record the final version as an audio file, a WAV file, MP3, etc. That audio file is now your sound recording. In the music industry, it's also referred to as the master sound recording. So let's assume you wrote and recorded the song all in one day. You own both the composition and the recording, the sound recording. In this scenario, you can go to the Copyright Office and fill out a Form SR to register both the composition and the sound recording in one filing. However, if you've already filed the composition using the Form PA, you can still use Form SR, but you only register the sound recording portion since the composition was already filed under the Form PA. So how does this come into play with cover songs or derivative works? Let's say your favorite artist writes a song. They own the composition. You want to do a cover of it using a guitar instead of the original artist's instrumentation. So you would record the song and file a Form SR, but you need to list your favorite artist as the composition owner and you or anyone else who helped you work on the new recording as the owner of the sound recording. The original artist always owns the composition. You own the sound recording. What if you want to do a parody or a remix and change up the original artist's composition? In this case, what you are doing is considered a derivative work. You are making a new song clearly based on the original composition, but changing it enough to make it different. You still need to note the original songwriter as the composition copyright owner, and you own the new sound recording. So once you record a song and you've copyrighted your work, who gets paid? Royalties. Give me my money. Royalties are, quite simply, money you make whenever someone uses your music. Here are some ways that you can earn those royalties from your music. Mechanical royalties. Earned when your music is reproduced or distributed. Streaming, downloads, CDs, or vinyl. Performance royalties. This is earned when your music is played publicly, on a radio, live performances, in stores or restaurants, etc. You have sync royalties. These are earned when your music is used in video media, such as movie, TV, YouTube, video games. Print royalties are earned when your sheet music or lyrics are printed and sold. And then sales. These are obviously earned when you sell physical copies of your music, MP3 downloads, vinyl, CDs, and etc. So in the first scenario, when you hear a song on Spotify, for example, there are actually two royalties being produced, mechanical and performance. The mechanical royalties in the US are collected by the MLC, which is the Mechanical Licensing Collective, and the performance royalties in the US are collected by the PRO, which is your performing rights organization, which we'll go into in a little bit. Scenario 2. You sell your MP3s on Amazon or iTunes. In this scenario, you have the actual revenue from the sale itself, as well as a mechanical license royalty. Scenario 3. A restaurant plays your song through Spotify. You get performance royalties since it's played in public, and mechanical royalties since Spotify reproduces your song in order to stream it. Scenario 4. A music store sells sheets of music of your song. You earn print royalties. And Scenario 5. A music store sells CDs of your song and also has your song playing over their speakers. You get sales royalties from the CD sales, mechanical royalties since your songs are being sold in tangible CD format, and performance royalties because your music is played publicly in the store. So now that you understand how you can make some of the money, the next question is, how do you collect it? And that takes us to get royalties like a pro. What is a pro? Here is a high-level summary of what you need to know to start collecting your money. I'll leave a link to the agencies that I mentioned below in the description. First and foremost, you need to register with a pro and other organizations that collect royalties, because if you do not collect your royalties in time, you will lose them. And this is something that I have just recently learned. I repeat, if you do not collect your royalties in time, you will lose the money. I've made this mistake in the past, and again, I want to make sure you keep what you have rightly earned. So once you've earned the royalties, how do you collect them? Well, first you need to become familiar with the following. Your pros are your ASCAP, BMI, or SESAC for performance royalties. And just so you know, SESAC, my understanding, is by invite only. But ASCAP and BMI, you can just go and register. Again, you have the Mechanical Licensing Collective, the MLC, for your mechanical royalties. And again, this is related to digital streaming and downloads. The music publishers for sync royalties and print royalties, if you're signed. Digital distributors, for example, TuneCore or CD Baby, for digital sales and streaming royalties. And then sync licensing agencies for sync royalties. So the first step is you want to register your songs with a pro. Again, ASCAP, BMI, SESAC. Now, this information is specific to the US. There are other international pro organizations as well, so this may not apply to you if you are not in the United States. A pro collects performance royalties from radio, live performances, streaming, and public places like stores and restaurants. You'll need to choose one pro based on where you live or where most of your royalties will be earned. A pro splits their royalties into two buckets. So you have a songwriter share, which equals 100%, and then you have a publisher share, which also equals 100%. So the pro counts it actually as 200% split between publishers and writers. So assuming you're an independent artist working as a sole proprietor without an LLC, you only need to register with one account as yourself, the songwriter. The pro will hold your publisher shares and allocate them to your writer account. Again, if you do have your own formal publishing company, you'll need to register with the pro using two separate accounts, one for the writer and one for the publisher, your LLC. Writer shares go under your name as the artist, publisher shares under your LLC. Now, some distributors do offer pro administration and collect those royalties for you. If you sign up for this, but eventually decide you want to collect your own pro royalties again, you'll need to cancel with the distributor and notify your pro of the update. It's possible to cancel distribution of your songs, but the distributor could still collect your royalties unless you specifically tell them to stop the pro publishing part. So the next step is you want to register your songs with the MLC and the Harry Fox Agency. You'll need to create accounts for each, which again we'll explain in more detail in a future video. Step 3 is to register with Sound Exchange. So Sound Exchange collects digital performance royalties from Pandora, Sirius XM, and internet radio. Assuming you don't use a distributor like CD Baby, you must register as both an artist and a rights holder if you own the recording. If you go through CD Baby, you'll still need to register to collect your artist's share, although CD Baby will register as a rights holder for you and collect that portion on your behalf. Step 4, you want to register for sync and print royalties if needed. So if you want your music in TV, film, or commercials, you can register with sync licensing agencies like Songwriter, Pond5, or Artlist. Or if you're using a distributor like CD Baby, they do offer a sync licensing service for a fee and will negotiate and collect on your behalf. So remember, royalties don't collect themselves. If you don't register your music, you're leaving money on the table. That's why it's so important to sign up with the right organizations as soon as possible so that when your music is played, you actually get paid. And that leads us to our next topic, licensing. How do I license my music? Licensing is how you grant permission for others to use your music while you're getting paid for it. Much of this will sound familiar because it ties in with the royalties we discussed earlier. Sync licensing allows music to be used in TV, film, ads, YouTube videos, and video games. Again, this is handled by sync licensing agencies. Some distributors, like CD Baby, offer sync licensing for a fee, and you can directly pitch to some music supervisors as well. Mechanical licensing allows other people to legally cover and distribute your song. So if someone wants to record and sell a cover of your song, they need a mechanical license. This is usually handled by the Harry Fox Agency or Songfile. So public performance licensing, this grants permission for radio, live venues, and businesses to play your song. Most businesses will pay for a blanket license with the pro. This is handled by pros. So again, if your song is played in bars, restaurants, or concert venues, they must pay a fee to the pro, and then you get royalties. Print licensing allows sheet music and lyrics to be sold. And again, this is managed by publishing companies or platforms like Hal Leonard and Music Notes. And bottom line is licensing ensures you get paid when others use your music, whether it's on screen, on the stage, or on paper. Licensing is key to protecting and monetizing your work. So that leads us to splits. Simply put, splits are how much of a song or a sound recording you will be paid for. So copyright and splits are actually separate things. I can own 100% of a song's copyright, but I can still choose to split my royalties with another person who contributed. So let's say you co-write a song with someone. You both own a share of the song. These shares are called splits. How do splits work? So if two writers agree to split a song 50-50, then each person gets 50% of the songwriter royalties and 50% of the publishing royalties, assuming that they have a publishing account. Otherwise, it defaults as they are the publisher as an individual. If one person writes lyrics and another person writes melodies, then generally they will split 50-50 or whatever they agree on. Work for hire. If you pay someone to write lyrics, produce, or compose, you need a work for hire agreement to own their share. Otherwise, they legally own part of the song. If you don't have a written agreement, then by default, it is legally assumed that all co-writers own equal shares even if one person contributed more. Final tip. As I learned much later on, before recording or releasing a song, always discuss and agree on splits in writing. It avoids confusion and ensures everyone gets paid fairly. The days of handshakes and verbal agreements, those are over. And that wraps it up. Thanks so much for watching. If you found this helpful, please remember to share, like, and subscribe. If you have any additional advice, then I would love to hear your feedback in the comments below. Also, please support a fellow indie artist and take a listen to my original song, No Power Over Me.